Hey, everybody. Welcome into the back room. I'm Andy Ostroy. Very excited for our first-time guest, attorney Danny Cevallos today. We will chat with Danny in just a second, but thanks for tuning in. We appreciate you listening, and we'd love to hear your comments. So email us at backroomandy@gmail.com and or post on our social media, and we'll read some feedback next time. And if you like the podcast, please follow or subscribe and rate and review, and you'll be notified every time we post a new episode. So, Danny Cevallos, he's a criminal defense attorney and MSNBC legal analyst. Danny, welcome into the back room.
Thank you for having me in the back room.
I've seen you on the news programs for a while. I've been wanting to have you on for a while, so it's an honor to have you here and talk about all the craziness that's going on. This has been a crazy week, hasn't it?
This has really been the craziest week. And, you know, it's hard for me to say that because in newsrooms, it's almost a common refrain. It's almost a greeting that you say to each other because it seems like it's always crazy. And especially in the last 10 or so years, the news has just sort of been crazy every week. But this week, this last week, maybe the week before, but this week in particular is particularly crazy. I mean, just on the legal front, there's so much going on, and every day has brought something new, whether it's Weinstein, which was unexpected, or Trump at the Supreme Court, which was expected, but momentous and would otherwise blot out the sun, except you have a Trump criminal trial going on this week as well.
Mm-hmm. It just really seems dizzying, and it's something that the American people, our political system, we've never experienced anything like this before. And so I was trying to think the other day, like, how would I put to words what I'm actually feeling? And the only thing I could think of is like if I went to the gym and I just started running as fast as I possibly could from weight machine to weight machine to weight machine to the pull-up bar to the elliptical to the Stairmaster to the treadmill and then back and forth and back and forth and back and forth and back and forth and only spend 2 seconds on each of those. That's what it feels like, following the trials, the hearings, the motions, the appeals. I mean, it's dizzying to the average person. It's got to be even more so to guys like you who are involved in it.
It is. And first of all, it sounds like you work out too hard because that is way too intense. Here's an analogy, I mean, that I think of because every time I find myself trying to explain, you know, I'm becoming one of those old guys that talks about what we had to do when I was young. And even something like a video game, if you try to explain an Atari or a Texas Instruments to somebody today with an Apple iPhone, I mean, it sounds insane what we occupied ourselves with. And so I always have these points I go back to. And when I was in law school, I'm dating myself, but the big news then was the Bill Clinton impeachment, and it occupied everything we talked about. And it was the story of the year. And now something like that would be a side story. We've had 2 impeachments in just the last few years, and now we have 4 criminal trials of an ex-president. It's not escalating; it's accelerating. It's not I think it's not geometric growth, but exponential growth. So you're right in that our white blood cells collectively haven't had a chance to adapt to it, and it's just overwhelming. I mean, there's no way you can compare this to things that were going on 10 years ago in a pre-Trump era. The only upside I have to say is that, boy, I guess in part thanks to someone like Donald Trump, we have now crystallized parts of the Constitution that we never touched before Donald Trump. I always go back to the example of whoever heard of the emoluments clause before Donald Trump became president. Mm-hmm. And whoever knew, you know, now before the court, we have this arcane interpretation of the impeachment judgment clause, which no matter which way it goes, I guess as somebody who's a fan of this kind of stuff, it is maybe a net good that we're developing this constitutional law. But, you know, then again, the argument could be made that if we didn't have all these crises, we wouldn't have to deal with these issues of law.
Yeah, and also there's an element of politics that's now being played out in the court system, especially in the Supreme Court, which I want to get to in a second and get your thoughts on that. But we were talking a few minutes ago about the craziness of it all. And in listening to the immunity hearing in the Supreme Court yesterday, where it sort of elevated for me and went from just normal crazy to insane crazy was the back and forth over the hypotheticals of what is and isn't under the umbrella of immunity. And listening to the justices, in particular, Kagan and Sotomayor, trying to get examples from Sauer of what would be acceptable. It was almost like a Saturday Night Live skit where it'd be like, okay, if Donald Trump reached into a stroller, took out a baby and punched it in the face. Would that be under immunity? Like, are we really discussing this? Are we really discussing presidential bribery being okay? Are we really discussing assassinations of opponents being okay? Doesn't that sort of escalate it to like a whole next level of insanity?
Yes, we are. And you know what makes it complicated is what I call bad facts. And sometimes you have these on appeal. I can think of a case right now before the Supreme Court called Rhiniecliff, which is a classic example of an important constitutional issue, but the facts are so bad that it colors your view of the legal issue. And I think with this, you have the facts, which are, I think, almost everybody. I don't know that anybody believes that Donald Trump was meeting with DOJ to really ferret out election fraud. I mean, maybe some people do. But that's why these are sort of bad facts. The issue of presidential immunity really lends itself to all of these crazy hypotheticals. And I have to tell you, I totally agree with you. This was a classic staple of the Socratic method in law school, which is come up with doomsday escalating hypotheticals. And they delivered them on both sides of the argument. And you're right. I mean, I'm torn too, because on one side, it can't be possible that Donald Trump, merely on his way to give a State of the Union address, who punches a baby in your example, that has to be can't be an official action. But you could hear people arguing both sides. And by the way, Trump's team concedes that purely private conduct would be something that an ex-president would be subject to prosecution for. But they cleverly they leave open what the heck is purely private conduct. What is it? Does anybody know after all this? So you have Trump's side conceding that purely private conduct is prosecutable for an ex-president. Then you actually had, on the government side, a concession of sorts that there are core presidential activities for which there would be immunity, but they were very careful not to call it immunity. And that led to a back and forth between the justices. And, the government got hit with some hard hypotheticals as well. And, one of the examples I think of all the time, and I still feel like is an undefined answer, is what's to stop a prosecutor in Grayling, Michigan, a county prosecutor who decides, you know what, some of our boys didn't come home from the Iraq War, and I think George W. Bush misled Congress. Therefore, I'm an elected prosecutor. I got a town here at 2000. I got elected. I'm going to file charges against George W. Bush. There's no statute of limitations for murder. My point is there are doomsday hypotheticals for both sides of these. The baby punching example, and then, of course, the example of a president who makes a difficult presidential decision, and it only takes doesn't require a federal prosecutor. It just requires some small town county prosecutor to decide that the president has committed murder or some other wrong and charge them. And I just have to say the one thing, and this is probably the criminal defense attorney in me, the one point I thought the government was weak on was that they assured the court that an ex-president's fears of being politically prosecuted are allayed. They're minimized because, after all, grand juries and prosecutors have discretion, and they would never bring charges that weren't warranted. They would never bring political charges. Well, forget the political charges for the moment. I mean, the reason we have appeals courts is because prosecutors get it wrong. And the idea that the government would argue that we're infallible, I thought was a real weak point. And the justices seized on that. In fact, I think that was one of those few moments of either chuckling or outright, snickering. I'm not sure. I can't remember. But look, I thought there were tough hypotheticals on both sides. It's such a difficult issue. And I think both the litigants want it to be simple. In other words, Trump's side wants it to be, hey, if this is arguably official conduct, if it's in the outer perimeter, then we're off the hook. The government, really, their argument, as I read it, is sort of, okay, we may not care about the full contours of immunity, but what Trump did, he's not immune. And that's it. We'd love to stop after that. We don't want to get into the thorny issues. But the justices pointed out, we have a bigger burden here. We are making a decision for the ages. And they're right. They may have to flesh out when presidential immunity applies and when it doesn't. And I don't envy them. It's a tough call.
Mm-hmm. Well, you're bringing up a good point, which Alito raised, which is that the court overall is not just focusing on this particular case, but the implications and ramifications for the future and every president that follows. But as a layperson, it just seems like so much of this is clear. that we're trying to take something that is clear and muddy it up. To use your example, okay, president is on his way to the State of the Union to give a speech. That's his job. But if he says, hey, stop, I want to get out and punch that baby in the face, like, how on any level are we arguing that that could be directly or indirectly tied to his job? It's like,
right.
We can go into...
I think that's purely private.
Yes, but that's not the argument that's being made, though, right? I mean, like every answer to the question that the justices made, and Sauer's answer was, well, it depends on the circumstances. Well, what circumstances would justify a president from getting out of the beast and punching a baby in the face on the way to the State of the Union? But that's kind of the point they're arguing, though, that would fall under the umbrella of presidential immunity.
Right. And neither side wants to get into those hypotheticals and commit to them, because really the only thing Sauer wants is immunity in this circumstance for this kind of conduct. So the argument, for example, that, hey, talking to DOJ lawyers about the election, that's got to be protected. But note that Sauer made some very important concessions to none other than Justice Amy Coney Barrett, who really cross-examined him and gave him not just hypotheticals, but literally language from charging instruments, from the president being prosecuted. And so, Sauer, I was surprised, was willing to concede some things. I do agree that he would, when hit with some really tough hypotheticals. In fact, probably the one that got a lot of press was the one at the circuit court when he was asked if SEAL Team 6 could assassinate a political opponent. He kind of bumpered on that answer, but he agreed on several points that there are certain actions that are purely private. So Trump's side seems to be taking kind of a middle ground, and I think I see their mission. Their mission is to say, look, we're not going to get total immunity, absolute immunity in all instances, so let's cede some territory. And if we can get this so the court is saying that purely private, but official conduct is immune, then maybe we at least force this to get sent back down to the district court for an evidentiary hearing. And that is a win. I do get the sense that maybe spiritually the Trump team has moved off, at least at oral argument, their original argument that all presidents absolutely immune for all official conduct forever and ever and ever. So I think this is an argument that might resonate with this Supreme Court. And I actually think they are going to find some degree of immunity, but absolutely not absolute immunity.
Well, you just raised a really interesting point, and that is the question over to Trump and his lawyers. What is the definition of win? Is winning the immunity issue, or is winning having this can kicked so far down the road that it either no longer matters, or he wins the presidency again and it just goes away?
It does go away. If he does win the presidency, he just gets an attorney general to dismiss the case, or he tries to pardon himself. But either way, the federal cases go away. The state cases do not go away. But, as riveting as this trial is in New York, I mean, that ends up being a Class E felony at worst for him. It could result in incarceration, but and the case in Georgia seems to be really sputtering. I don't know what's going on with it, and I haven't been blown away by some of the choices the prosecution has made in the Georgia case. But you're absolutely right. Delay is quietly the unspoken mission and anti-mission of both the government and the Trump team, in that delay is a win as to the federal cases. So that's all good. And by the way, so too is a win if there's any immunity, because that's a big step up from really how they've lost that issue at every level up till now. They've lost to the district court, they've lost to the circuit court. So a finding that there is some degree of presidential immunity is a huge win. When you're on the defense, anything you can do to carve away at an indictment is a win. And if some of former President Trump's conduct when he was president is covered, and there is immunity forever and ever when he's an ex-president, that is a major win for Donald Trump.
So if the goal ultimately, in part, of winning is to delay, is it your opinion, to the points you've been raising, that that's their strategy? Like they are fighting a war to delay, not a war to win on the issue of immunity?
No, I mean, I try to think like the lawyers. I think that's what Trump wants, but I think these are, he's got an appellate lawyer in John Sauer, who I think is really arguing these points. I think he gets caught on some of the trickier parts of it. For example, the impeachment judgment, I guess they're calling it immunity or double jeopardy prong of their argument, which we haven't talked about yet, but which features prominently in their arguments. I think that's a stretch. And I think John Sauer has been stuck on that argument because it doesn't make a lot of logical sense. But I do think his attorneys are really looking to win on the issue of partial presidential immunity. Look, they'd love absolute immunity for all ex-presidents, but they're not going to get that. And I think they're starting to realize that. So I think that's why you saw an oral argument, maybe the sense that they're perfectly willing to agree that there may be conduct that this ex-president is chargeable for, but not all of it, and a court has to determine it. And then a happy byproduct of it for them is delay, which obviously pleases their client.
What do you make of what Alito suggested, the hypothetical that if a president who doesn't have immunity believes he will face prosecution once he leaves office, might attempt to cling to power, and therefore that's a reason to rule in favor of Trump?
Yeah, I mean, I think that was an interesting one of the doomsday scenarios, but I think one of the more realistic ones was also raised yesterday, which is, will this result in every president on the last day of office trying to pardon themselves? I mean, that would just be an awkward situation in America if every day on the last day, I know there are a lot of uncomfortable, awkward pardons that are handed out, but as a matter of course, 20 years from now, if it was a presidential practice to pardon himself on his last day in office, I don't know. It would, on the one hand, would it really change American life at all? No, but would it look good? It would look a little banana republic to me. Mm-hmm. So that was one outcome. The fear generally that presidents would be prosecuted. By the way, I think, I mean, you know, the government's representing the government, but I think a very real concern is if Donald Trump gets back in office, who's to say he's not going to find an attorney general, and I'm sure he can find one, who thinks that things that Joe Biden did were criminal. Forget the most recent special counsel investigation of Biden. They'll find something else, and then they charge him. I mean, that is a very real possibility to me, which is why the immunity question is a question for the ages. It's just complicated because on these facts, I think almost anybody who looks at these facts doesn't doubt that what Donald Trump was doing was not only as a campaigner and not a president, but purely personally motivated.
Yeah, there was a question I was going to ask you at the very end, which I'm actually going to ask you now because you just triggered it for me. Do you look at what's happening now and say, you know what, with Trump, everything we're experiencing, it's just a once-in-a-lifetime phenomenon that's never going to happen again because there's no one like him? Or do you think the constant erosion of our boundaries and our norms and our standards and the incessant breaking of the law and just the willful nature of it all by Trump and his cronies, is this our new normal going forward?
Yeah, boy, that is an issue way beyond my legal ken. I guess legally, I think that...
And if I could just interrupt you for a second, the reason I decided to ask you it now is because what you mentioned about could a president find a compromised attorney general who would prosecute the former president? Like,
right.
If we're considering that, not when it's Trump, but when it's just someone else, right?
Anyone.
Is that our new normal? Which would have been unheard of before Trump.
Right. Here's why I think maybe not. I mean, I might have thought, I'm hopeful because I just look at the Republican primary and the incumbent President Biden running. I mean, the advent of Trump has created some Trumpian characters, but the Republican primary had a lot of faces we'd seen before. It wasn't a bunch of wild and crazy characters. I mean, you could argue that Vivek was kind of a Trump acolyte, but I mean, Nikki Haley, some of the other folks, we know who they are. We've seen them before. Ron DeSantis, maybe more conservative than most, but I wouldn't even say the most conservative guy up there. I mean, maybe you could say Trump's vice president bowed out early. So I don't know. I don't know that we're seeing the leaders who would escalate the way. There's no leader that's been like Trump, that behaves like Trump. I mean, the mystifying thing is why acting this way works for him. I mean, maybe this is just a singular event in American history, a one-time incident. Still, Trump has created a political atmosphere where people who support him can be, pretty excitable. I still think that once Trump is out of the picture, whenever that is, I think, I do think everything escalates, but I also think that Trump is a singular, unique character. And there isn't really anyone coming down the pipe that is exactly like him. And I mentioned Vivek, but even Vivek during his interviews was more than willing to say, I would make much different choices than Donald Trump.
Mm-hmm. Yeah, I would tend to agree with what you said. Last question on immunity. How politicized do you think the court has become, especially in this particular case?
Since law school, I was always fascinated by the idea of originalism or textualism, because I believe that, it was an idea among conservative justices or conservative legal theorists that you look to the intent of the law without fear or favor or, applying morality, and even knowing that sometimes applying the law as written, as contemplated, might yield unfair results. That's an issue for Congress or the legislature. So I did think that this would yield always fair results. The troubling thing for me is that when I see that the Supreme Court, for example, when it becomes predictable, that concerns me. When you can sort of count on certain votes on either side. So, I mean, to some degree, you could say it's political, but don't forget, every justice on the Supreme Court, yeah, they were selected, sure, because they're good people, I'm sure, but they were also screened and screened and screened to make sure that they would be someone that would be consistent, that would hold the line. I mean, it wasn't too long ago that there was a term called being suitored when I believe it was Reagan who appointed Justice Souter, and he got roundly criticized when he would make a number of decisions that went counter to the conservative viewpoint. So, I mean, I don't think any justice, conservative or liberal, is up there thinking to themselves, I've got to toe the line. I mean, we didn't design the Supreme Court that way. Do they end up deciding that way? Yes, but I mean, they were picked for their bona fides, which is fine. I mean, they lean certain ways. So I don't know that they're politicized. I think each justice is their own creature and trying to make their own name. And I think they're trying the cases. They're deciding the cases to the best of their ability. But they are who they are on both sides. Some of them are liberal, some of them are conservative. So I mean, I couldn't fault any one of them for deciding the way they do. I often find that I understand the reasoning in a dissent, and I understand the reasoning in a majority opinion.
Well, when you consider that this case will, when it all is said and done, given what we're talking about and what we now know, will probably take upwards of a year to finally resolve. And then you look at the expediency with which they pushed through the 14th Amendment case in Colorado, which I think was wrapped up in like 4 weeks. It's hard to say that it's not political. But let's turn to New York. What are your top takeaways of the trial this week?
Well, I thought David Pecker, so far, he's not even finished, has been the people's star witness. He's been their only witness, and they've come out with a bang. I mean, he's interesting. I was fascinated to learn about the world of checkbook journalism, which is the tabloid journalism. That's what he called it himself, paying for stories, catching and killing stories. I mean, there were moments that I found downright hilarious. I mean, I thought it was really funny that during this testimony, all these other celebrities got hit with sex scandal shrapnel, during the I mean, poor Arnold Schwarzenegger was probably thinking, hey, I have nothing to do with this. And now I'm getting name dropped. You had Mark Wahlberg mentioned, Tiger Woods mentioned. And so I thought that was fascinating. And of course, if we're all finding it fascinating from outside the courtroom, jurors are going to be riveted. And believe me, they're going to be bored at times during this trial. I don't think David Pecker was boring at all. And the entire time, as he was on direct, I found myself thinking, well, what are they going to cross him about? This is a really tough witness. And they went after, so far they've done exactly what, really the only thing you can do with a witness like this, who's essentially a cooperating witness. You can challenge his ability to remember things. You can challenge his bias. You're here on an immunity deal. You're here to please these prosecutors. You made a deal and you're holding out your end of the deal. And that's pretty standard fare. And then specific to this case, they explored, well, this kind of thing had been going on for years and years and years, unrelated to the campaign. Your relationship goes all the way back to the 2000s, which obviously predated the campaign by over a decade. So I expected them to explore. I don't know that it was effective. I think the people have done a good job of putting their case in, and it's only just begun. I'll say this. I really had doubts about this case legally and as a choice, a prosecutorial choice. I think that if you look at the data, this is not ordinarily the kind of case that's brought with falsification of business entries. And so for that reason, I think there are concerns about prosecutorial discretion here. Now that the case is in, looking at the elements they need to prove, so far, they've had a pretty strong case. So, I mean, they're on the way. David Pecker, I mean, basically was obviously prepared and said things like, yeah, I did it for the campaign. I mean, they can make some inroads on cross-examination, and that's not getting over the finish line. They need the circumstantial proof that Trump had that intent. Mm-hmm. They got some of it from David Pecker, but they're going to shore it up with more than just David Pecker.
So you think on the key issues of intent and demonstrating specific criminality and conspiracy with Trump at the head of all that, you think, A, that this was a good week for the prosecution, and B, they're on their way to proving that even further?
I think it was a good week for the prosecution. I think here's what you can say. They're pretty close to establishing that there was catch and kill going on with these stories, with these women and with other people. I mean, you could say the doorman was related to a woman story. These catch and kill stories went on. That I don't know that they're going to dispute that they existed. I think it's pretty clear at this point that Michael Cohen was involved. There's evidence of that now. There's evidence that Donald Trump was involved. There's evidence that Donald Trump knew what was going on. There's evidence that he approved of what was going on. There's also some evidence from David Pecker that this activity increased as they got closer to the campaign. And David Pecker has essentially testified that it was in order to preserve the campaign, to protect the campaign. That doesn't get them over the finish line, but it might be enough already. It might be enough to defeat a motion to dismiss by the defense, which means that there's some evidence of those elements enough to survive a motion to throw it out, which is a big hurdle. I mean, that's a big milestone. And again, we're at the very beginning of the people's case.
So my last question is more of a macro question. Months ago, lots of people, and even to this day, we still hear some of that, and you alluded to that a minute ago, that this was not a serious case. It's not that important, not that significant. Why is this the first one that's being tried? Oh my God, there's so many more important things. Now that it's started, and now that we see all the potential delays and obstacles with the other cases, this case seems to be much more significant, not just because Donald Trump is literally sitting in a courtroom as a criminal defendant, but that the case itself is not, it's not just about hush money. It is about election interference. There's an election interference case in Georgia. To me, this case is an election interference case in New York. Do you see it that way? Do you see that this case has sort of taken on new stature and importance?
I can't compare this to Georgia or the D.C. election interference case because I do understand that it's been framed as a hush money and election interference case. The people of New York, the prosecution has to frame it that way because that's part of their proof. If it was just hush money, that's not good branding for them because it means they lose. It means at best they get a misdemeanor. They need to brand it as an election interference case. I don't put it, and again, this goes to why I'm
also
not
falsification,
a huge fan of bringing this.
Also falsification of business records and campaign finance violations.
It's falsification of business records with the intent to conceal a crime, and that underlying crime, we have learned very recently, is going to be a violation of election law, state election law. So I mean, it's not election interference of the kind that's alleged in DC and in Georgia, which is literally picking up the phone and interfering with the election. The theory is a little more, is not as direct. It's the idea that by helping out Donald Trump, that was a help to the campaign, and it was an unreported help to the campaign. Therefore, it's election interference. I mean, I think that's why Trump's counsel hazarded a statement that I think was ill-advised in his opening, which is, influencing elections is fine. I'm paraphrasing him, but he said something to the effect that people try to influence elections all the time. That's democracy. And he's right, but it might not have been the right statement or an opening statement in a criminal trial about election interference, because the theory of election interference in the New York case is just not as direct as it is when we talk about election interference in Georgia and DC, which is flat out obvious election interference, at least as alleged. Picking up the phone and calling Brad Raffensperger and saying, you and your lawyer could be in a lot of trouble if you don't do what I tell you to do. When you're by the way, if you and I did that, who cares? We're private individuals. But when you're the head of the executive branch and the DOJ, nominally at least, that's a pretty intimidating thing. So, I mean, the idea of election interference is much more obvious in DC and in Georgia. But when I think of New York, I think that the average person might not even realize that in-kind contributions to a campaign are something that need to be reported, can't be concealed. And I think it might be a hard sell to an average person that itself is election interference, at least when compared to Georgia and DC, those ideas of election interference.
Mm-hmm. So you're one of the only people that I've heard talk about jury attrition in this case. What's the biggest concern there for you?
Well, so far it's been pretty good since the beginning of jury selection. And like a lot of my predictions, they don't come true. But initially, when you select juries, it's not uncommon to lose jurors to all kinds of different things. They might get sick. They might have a personal issue arise. But only in high profile cases do you have the situation where they don't want to be involved. I've had jury selection in, more gangland organized crime cases where jurors are crying. They don't want to be on the jury. They're afraid of reprisal. And I get it. What you don't normally have, you definitely have juror attrition throughout a case for all kinds of reasons. You don't normally have you lose jurors from the time they're selected to before opening statements begin. And you did have that in this case. You had 2 jurors that were removed from the jury before the case really even began. So I was concerned, and I guess I still am, that juror attrition could be a thing. But so far, we're a week into testimony and no problems since. So I guess fingers crossed, we might be okay. But, I was concerned from the outset that the 12 jurors and the 6 alternates, that may be fine for the vast majority of cases, but is it possible in a Trump trial that you won't burn through all of them and all the alternates and then have less than a complete jury, which would result in a mistrial? So, but this week, we didn't really lose any other than the ones we lost before the trial even began.
Well, I 100% share your concern. Danny, this has been great. Thanks for the insights. Hope you'll come back and talk with us again.
Andy, thanks for having me, and please have me back.
All righty. Take care. This episode of The Back Room was edited and produced by me, Andy Ostroy. It was co-edited and co-produced by Matty Rosenberg and co-produced by Jen Hammoud. Our theme song was composed by Andrew Hollander, and our logo was designed by Cricket Lengyel. And special thanks to Patricia Wind. Please take a moment to rate and review the podcast, and also follow or subscribe. Until next time, keep your eyes on Washington, Hollywood, and your own backyards, and have a great week.